What is moonlighting and is it legal in India? My name is Ramana Reddy and I'm a practicing lawyer at the High Court of Telangana. Uh, I've got a lot of questions on moonlighting and whether that is legal. So, what is the problem? Let's first discuss the problem and get clear on what the problem is before we talk about what the answers are. So, moonlighting is generally a practice where somebody is working two gigs. That is the general perception. But I think we need to unpack that a little bit. So, let's say, for example, that you're a freelancer and you work on multiple projects. Does that mean that you are moonlighting? No, because the understanding as a freelancer is that you work on a non-exclusive basis. So therefore there can be no question of you moonlighting. Now moonlighting happens in two situations. The first situation is when you hold a full-time job and you also have some kind of a freelancing project on the side, or you could have a job and you could a full-time job and you could also take up a second full-time job. And typically these two categories are the categories with when people talk about moonlighting. Now what is moonlighting? Moonlighting is basically when you have your day job and when the moon comes out at night you are working a second job, or you are working, or you're freelancing in your industry. You could be working the night shift and you could be working when the sun is up. So that again, may not technically qualify as with the moon, but I think you get the idea. Is that you cannot, that whether you can work a second job along with your first job, and whether you can take up a second gig when you have a full-time job already. That really is the question. Now, I want you to stick to the end because I will tell you how you can do it without getting into legal trouble, how you can take up multiple gigs without getting into legal trouble. Now, before we get there, what are the concerns basically? As an employer, the concern is that my employee who runs, say, a YouTube, so let's say, there's somebody who's a chef and he also has a YouTube channel. Now, as the employer, my concern is he giving his 100% to the restaurant, or is he, if he's working at night, at making all these videos, then what about productivity loss? What about, is he taking my secret recipes and sharing them online? So that's a problem for the employer. And there are other issues also, is there a conflict of interest? So for example, an IT professional working with Apple, takes up a gig with Microsoft. Is there a conflict of interest? Is there any sharing of confidential data? So these things are on the top of the mind of any employer. On the other hand, for the employee is basically like, this is my life. I have to work for you for 8 hours. I am doing that. And apart from those 8 hours, it's my life. If I want to take up a gig, I should be able to take up a gig. What is your problem? So, we have people on two ends of the spectrum who have, different problems. Now, is this legal? And, that's why you're here. Now, I'm going to give it to you as in, put it as simply as possible. The most important document that you have to see is your employment contract. If you have a full-time job, because moonlighting only kicks in if you have a full-time job. If you're just a freelancer, there's no such thing as moonlighting. So the most important thing to look at is your employment contract. Now, standard clauses are part of employment contracts, which typically say that you cannot compete with the firm while you are working for the firm, or you cannot take up other employment with the firm, or basically that you have to give 100% of your effort to the firm or the company when you are working with them full time. So the employment contract is what governs. There is some argument to be made that, let's say that you are working for an India-based software company and you take up a gig at a US-based software company. Does that mean that you're actually competing with the India-based company? Because we're talking about totally two different markets. There could be two different products and so on. So non-compete, I'm not fully convinced that could be an argument, or even non-solicit, that you're soliciting customers of the company. Because if you're just working a gig with some random company somewhere, does that mean that while I hold a full-time job, I am prevented from doing that because I'm soliciting clients of the company? No, they're probably most likely not clients. But these are not the biggest issues. Actually, the biggest issue is that courts in this country generally are very reluctant to hold that an employee can do what he wants while he is working full time. Now, don't get me wrong. Now, courts understand that there is a difference in bargaining power, because the employee needs the job more than the employer wants to give out the job. I mean, that's at least that's the assumption. So generally, courts favor employees in these kinds of arrangements. But there is one very specific exception, which is that courts favor employees if the employer tries to restrict the employee after his employment contract is over. So let's say I work with a company for 2 years. I left the company, and now there are clauses in the company that says you cannot work in this industry, you cannot work with Mr. X, Mr. Y, you cannot work with my old customers, and so on and so forth. In those situations, the courts say, look, the employee has to earn a living. He has a right to earn a living. And so therefore, these kind of clauses in a contract are bad, and no court in this country will enforce those kind of contracts. But on the other hand, if the employer says that within, while you are working for me, I'm not saying that after you quit the company, but while you are working for me, you cannot work with another, a second employer or another freelancer, then courts generally uphold these kinds of clauses in the contract. Especially so an employer, if an employer, the first employer, can come and sue you and say, and he can obtain an injunction against you saying, don't work for a second company while you are working with me. And that is completely possible. In fact, if you have a second job, you may even run into like criminal trouble, because because when you're signing up for the second employment, you are actively concealing from your second employer that you already have a job, and that may amount to fraud and cheating under the Indian Penal Code. So that is definitely not recommended. Now, what is the best way that you can structure things so that you don't get into this kind of trouble? In my opinion, the best way to do it is to become a consultant. To become a consultant who works with people on a non-exclusive basis. But that's a trade-off. That's something that you have to think of, because as a consultant, you don't get a lot of the benefits that everybody else gets as employees, because you may not get, say, health insurance from the company. You may not get PF, ESI, and these kinds of things. But really, if the argument from the employee is, look, I have dreams, I have ambitions, so hands off, then I think if that is your thinking and that is your mentality, then I would suggest that you become a non-exclusive consultant, where you can work with different companies, and even within the same industry, and your contract specifically says that. Even if you're an employee, no matter whether you're moonlighting or not, I think you should always ask for a copy of the employment contract, because at least what you are being bound to. But with that aside, as a non-exclusive consultant, I think you get the freedom and the flexibility. But I think there's a more fundamental point, which is, it does not really matter whether, what the real test is whether an employer will hire you as a non-exclusive consultant. Is, do you have the expertise, do you have the skills in your industry to be able to at least dictate terms, at least to a certain level, which means do you have skills that are rare, do you have skills that are valuable, that are hard to find in the marketplace, as to which would get the employer to consider you as a non-exclusive consultant and say, okay, fine, I can work with you, you're free to work with anybody else. So I think if you want to really moonlight, or which basically means you want to work when the moon is out and you want to work with multiple people, then you should really focus on building valuable skills. You should really focus on building skills that are rare in the marketplace. And I think that puts you in the best position, not only for financial freedom, but also to get away from all these legal headaches, and where you can just focus on your work. I hope that was helpful. Thank you for watching.